we'll hear from the appellant when you're ready.
May it please the court, Will Perry for appellant, Memphis Shelby County Schools. I'd like to reserve 3 minutes for rebuttal.
3 minutes, that'll be fine.
Thank you, Your Honor. In March of 2018, Memphis Shelby County Schools placed appellee Lagina Scott, a tenured professional school counselor at Southwind High School, on administrative leave without pay. In May, they fired her. 15 students had failed to graduate solely due to appellee's errors. Those students were allowed to walk across the stage but had to attend summer school to actually finish their high school educations. Another 20 to 30 students had to complete virtual school online to make up in 6 weeks work that they had missed over 18 weeks due to appellee's errors. The teacher tenure law allows tenured teachers and counselors to be fired for any one of 5 statutory causes. The schools provided 3: neglect of duty, insubordination, and unprofessional conduct. All 3 charges were found by a hearing officer and sustained by the school board. But the trial court reinstated Ms. Scott and awarded her back pay. For 3 reasons, that reinstatement should be reversed. First, the preponderance of the evidence plainly reflects that appellant flagrantly and repeatedly neglected her duties as a professional counselor. Second, Tennessee law requires only disobedience and not intent to establish insubordination, and the record is equally clear that appellee repeatedly failed to follow her supervisor's instructions. Third, nothing in Tennessee law requires proof of malicious or criminal intent to prove a charge of unprofessional conduct based on unreliability. The trial court erred in holding to the contrary. For these reasons, the trial court should be reversed and appellee's termination should be restored. First, with respect to neglect of duty, there are several key things that appellee failed to do that establish that she neglected her duties. She failed to perform transcript audits. She was given multiple opportunities to do so and did not. She failed to conduct one-on-one student conferences. In fact, she did not begin to hold one-on-one student conferences until after the deadline for her to complete those conferences had already expired. She did not provide weekly reports of her status updates as requested by her vice principal and later interim principal, Mr. Chris Hardiman. She only gave 2 such reports during her students' senior year. Finally, she failed to properly schedule students for their classes, and she missed multiple opportunities to do that also. The trial court said that these errors, which are undisputed in the record, were the result of bad management by the schools. The trial court said, for example, that appellee asked for help and she was not given it when it came to scheduling her students' courses. But in fact, Vice Principal Hardiman actually entered appellee's student schedules for her after she had missed 2 deadlines. He did that for her. Despite numerous prompts and extensions, appellee simply did not do her job. The second basis for appellee's termination was insubordination. In September of 2017, appellee received 3 directives from Mr. Hardiman, who again was her vice principal and then became interim principal at Southwind High School. When he became interim principal the following month, in October, he reiterated those 3 directives. He said, I would like you to perform transcript audits. I would like you to conduct one-on-one student conferences. And I would like you to participate in something called the Senior Cohort Committee, which was a group of educators who were kind of dedicated to making sure the students graduated. He gave her a performance plan. She did not follow it. He gave her extensions to conduct the transcript audits. She missed the extensions. She only attended one meeting of the senior cohort committee, and she did not complete any of the tasks associated with committee work. She offered no explanation for failing to attend the committee meetings or for failing to complete the committee work. This court explained in the Elmy versus Cheatham case that a teacher is insubordinate when he or she refuses or continually fails to obey or to comply with the rules or to carry out specific assignments made by the principal, provided the rules and assignments are reasonable and not discriminatory. In her brief, the appellee cites Elmy as authority for the proposition that she was given assignments that she could not complete. The teacher in Elmy was directed to be in two different places at the same time, to be in her classroom and also to be directing students into class at the same time. So the court there held that those requirements were unreasonable because no person can be in two different places at the same time. That is not the circumstance at issue here. There's not even any allegation that appellee was asked to do multiple things at the same time and failed to do them. To the contrary, she was asked multiple times to do the same things and failed to do them. And as a result, her students were not able to graduate. The third basis for the termination of appellee's employment with the schools is unprofessional conduct. I think the parties agree that there is no definition in the statute or in the case law for unprofessional conduct due to unreliability, which is the basis on which the schools relied here. The schools therefore asked the court to apply a plain language reading to that term, unreliability. Again, it's undisputed that appellee failed to schedule her students. She did not conduct transcript audits. She did not meet with her students one-on-one until after the deadline had expired for her to do so. It is undisputed that 15 of appellee's students were unable to graduate solely due to counselor error. It is undisputed that 20 to 30 of those students had to attend online school. The Memphis Shelby County School District calls online school the virtual school in order to graduate on time. And for that reason, the third basis for terminating appellee's employment was her unreliability.
Mr. Perry, let me ask you a question.
Yes, Your Honor.
In the briefs, there seems to be some conflicting testimony or about FMLA leaves that Ms. Scott was on, and whether those were 2 years, part of 1 year, part of another year. There just seems to be conflicting testimony about that that's referenced in the briefs. And again, as I said in the other case, I haven't looked at the record, but I've read the briefs on it. So does that even matter for the purposes of this proceeding? Does it matter when she was out, or how many times she was out, or how many days she was out?
First, Your Honor, I respectfully no, but there's no conflict. There's some testimony in the record from Mr. Hardiman, who was her principal, and he erroneously stated that appellee was out for portions of 2 years. She was only out for portions of her student's junior year, which is fall 16 and spring 17. She was out for part of the fall. Her son had some challenges, and then she was out for part of the spring because she was involved in 2 accidents. She had a car accident, got a rental car, and then she was involved in an accident with a rental car. So that I think there was some confusion on behalf of one of the witnesses, Mr. Hardiman, in one of his testimony. He, I think, suggested that she was out for part of her student's sophomore year and part of their junior year. I think the record plainly reflects that the guidance counselors at Southwind traveled with their students. So they started with the students in 9th grade, then went with them to 10th and 11th and 12th. But she was only missing for a good portion of the students' junior year. She was not missing. And the trial court's order actually reflects that. It was the 16-17 school year where she missed a portion of the year due to some challenges with her son and some car accidents. She was not out for 2 years.
Okay. Thank you.
I'm happy to answer any other questions. There are 2 other issues raised in the briefs. One is the issue of back pay, and then the other is due process, which appellee admits is permitted. I'm happy to rest on my briefs with respect to those issues unless the court has questions.
I hear none. So
Thank you, Your Honor.
Thank you, counsel. You have your time for rebuttal.
Thank you, Your Honor.
Hear from the appellee.
2 in 1 day, huh? If it may please the court, my name is Darrell O'Neilly, and I, along with Ms. Smittick, represent Ms. Lagina Scott. And we're here today to respectfully request this court to affirm the decision of the trial court. I heard the questions. I think the trial court got it right. The one thing that counsel says that I absolutely agree with, and the chancellor said it, bad management. You asked how many years? We got to look at the record. Mr. Hardiman, who is her supervisor, her principal, testified she was out about 2 years. The record will show that she was out during the time period between 2015 and 2016, and it's undisputed that she was out almost all of 2016, 2017. She actually came back in the beginning of the student's senior year, and that's the issue. So Ms. Scott was out for this long period of time. For that year and a half, almost a year and a half that she's out, they don't put a counselor in. There's no counselor in this job at all. Then, all of a sudden, at the last semester before Ms. Scott is getting ready to return, they put Ms. Good in. Here's the problem. Ms. Good can't upload schedules. Ms. Good doesn't have access to Power School. Ms. Good can't do anything. The problem is, and when my client comes back, when Ms. Scott comes back, she doesn't have access to Power School. She can't upload schedules. The principal, in fact, did upload schedules. I agree 110%, but he did it the wrong way. What he did is he uploaded everybody's schedule first, and then he uploaded the seniors last. Well, the problem is when you upload all the freshman, sophomore, and junior schedules first, what ends up happening is there's no classes for the seniors. Normally, you upload the senior schedules first, and then everybody else gets what left. So Ms. Scott comes back. Now she's got to figure out how to correct these uploads. She doesn't have Power School. She needs the training for Power School. Then she does what any person would normally do if they're overwhelmed. She asks for help. It is undisputed that she asked for help. Undisputed. And the principal said, no. I would rather these students fail than help you. I didn't say that. It's in the transcript. It's the volume 3, page 276 to 277. The principal made it clear that he knew Ms. Scott was struggling and that it didn't matter if the students failed. So now we're going to flip the script. We want her to fail, and we want the students to not graduate, but then when it happens, we're going to penalize her for it. That's what they did in this particular matter. Ms. Good, who was not a counselor and did the best that she could do without the skills that she needed, she testified that the job was overwhelming. She gave an entire presentation before Ms. Scott came back to the administration. And you know what the administration did with that? This is the reason why the chancellor said bad management. Ms. Good gave an entire presentation of all the things that need to be done and all the things that need to be corrected and what she needed to do. And here's what the school system said with that. Nothing. We're just going to wait till Ms. Scott gets back to figure it out. The one thing that the record doesn't identify here is Ms. Scott was a counselor. So before you become a counselor, you have to be a teacher. So she was a certified teacher, and she got promoted to the position of counselor. If she couldn't do the job as counselor, why not just demote her to teacher? She had no disciplinary history, but they decided, because you can't be a counselor, we're not going to put you back in the teacher pool. We're going to get rid of you. Now, the chancellor, again, when you look at this unprofessional conduct, and it says grossly unprofessional because immoral or dishonest. I didn't see anything in the record to support that charge. Then it says that Ms. Scott was neglectful for duty. I'm doing everything that I can do. Neglect means I took a purposeful action to not do what you asked me to do. That's the scenario in Elmy. It wasn't the fact that it was asking Elmy to do two different things. It's the fact that Elmy's trying. I'm late, because Elmy was late a lot. But at the end of the day, I'm trying. I'm not intentionally doing things wrong. Ms. Scott did not have, you penalizing me for not uploading the schedules. I don't have access to Power School. You penalize me because I'm not moving fast enough. I don't have the training. I ask for help. You penalize me because the students don't get in the process. I don't know what else I can do. So that's the reason why the chancellor believed that she was not neglectful in her duties. He also believed that she wasn't insubordinate. How can you be insubordinate when you're trying? Insubordinate means I'm not going to do it. I'm going to say to you, you tell me to do X, I'm going to say I'm not going to do it. There is nowhere in the record any testimony where Ms. Scott refused to do her job. I tell you what is in the record, that she asked for help on numerous occasions. And in fact, when the principal didn't give her help, she went and found her own help. And then when the principal found out that she was getting help, he told those people, stop it. Bad management. And that's what the chancellor determined. And as a result of it, the chancellor believed that the termination of Ms. Scott was inappropriate, and he reinstated her. And because of the chancellor's rulings, we ask this court to affirm the decision of the chancellor. Subject to the court's questions.
I hear none.
I'm glad you visited us from East Tennessee.
I always enjoy being over here.
Thank you.
It's nice to hear different lawyers. We'll hear from the appellant rebuttal, sir.
Thank you, Your Honor. I'll make 4 short points on rebuttal. First, my friend on the other side says that appellee asked for help and she didn't get it. The school district hired a substitute counselor while appellee was out, gave her multiple opportunities to meet deadlines that she continued not to meet. Her principal, when she was unable to meet the particular deadline of entering her students' schedules, entered the schedules himself. That's help. With respect to Power School training, it's undisputed that the original Power School training was given to the other counselors while appellee was out. When she returned, she completed the Power School training. That is an undisputed fact. That is paragraph 23 of the trial court's order at volume 1 of the record at page 126. She did complete Power School, and still she had problems complying with her duties. You heard from my friend.
Did the other counselors that were instructed, were they instructed, was it an online module, or were they were given the same instructions that she was?
That's my understanding, Your Honor, and also that when appellee asked for training on Power School, she was told to do the online quizzes so that she could get up to speed on what she needed to learn about Power School, and she did complete the Power School training. Okay. There's a quote, you heard my friend say that appellee's principal was willing to let her fail rather than help her. I will just refer you, if you'll take a look at page 7 of our reply brief, it has the quote from the principal in full and not just the excerpted portion in the appellee's brief. But here's a piece of that. The principal was asked, why didn't you take it upon yourself to make sure that appellee had assistance on Saturday, August 5th, so that the deadline could be met? He responded, because at this point it was her responsibility to ensure that the schedules were done. And then he says, barring the 2 days that she was behind, she still had time enough to be able to get all of those schedules done because the previous counselor, Ms. Good, when she was the substitute counselor, left student course selection sheets that were based upon a transcript audit. Had she used those documents, she would have been able to easily go through and schedule all students. That's the full quote, and that's again on page 7 of our brief. I'm happy to take any additional questions. Otherwise, we'll rest on our briefs.
I hear none.
Thank you, Your Honor.
Of course, thanks to counsel for both sides. We appreciate your arguments and your briefs today. It's a